This proposed equality bill fails to protect or advance the rights of all New South Wales citizens, especially children. It privileges a select few at the expense of the many, undermining basic human rights rather than ensuring them. Far from combating discrimination, this bill risks increasing the vulnerability of women to male violence and exploits children in distress for commercial gain. Firstly, this bill proposes to shift our legal norms away from recognising biological sex. Fundamental for ensuring fairness and safety, to embracing subjective, unproven concepts of gender identity. This undermines critical protections for women, children, and the very structure of family rights, erodes safe spaces designed specifically for the most vulnerable among us. Secondly, by prioritising self-identification and internal perceptions of gender, the bill fails to consider the medical, societal, and practical implications of such a policy. It neglects the necessary balance between the individual rights and societal needs, leading to serious harm to the groups it seeks to protect. Moreover, this bill in its current form risks advancing the rights of one marginalised group at the considerable expense of other groups, particularly women, children, and the homosexual, bisexual community, the LGB. This creates a paradox where the pursuit of inclusivity for gender identity minorities results in a regression of rights for other historically marginalised groups. These outcomes not only contradict the principles of fairness and equality, but will embed systematic discrimination against these groups, thereby rolling back decades of progress in sex equality and sexual orientation. The committee must undertake a rigorous and common sense review of the bill to ensure that advancing the rights of one community does not unjustly infringe upon the women, children, and the same-sex attracted. It is imperative that any legislative changes preserve the protections based on biological and evidence-based realities, uphold rights to privacy and safety, and maintain the integrity of the law in representing and protecting all citizens of the New South Wales equitably. We have many concerns with this bill, not the least that it reflects international financial and political collaborations, rather than the wants and needs of the general Australian people. Firstly, we're concerned that the findings from the Cass Review are being ignored. The Cass Review prompts a crucial reconsidering of how gender-affirming care is approached, particularly in legal and medical contexts. This is pertinent to sections 2, 3 and 16. The family court's rulings in Australia, notably Re Jamie 2013 and Re Calvin 2017, carved out exceptions for gender affirmation treatments. These decisions recognise that gender-affirming treatments would carry significant risks and consequences for minors, including sterilisation. They deemed this necessary, told that this would prevent severe distress and risk of suicide. The Cass Review undermines the justification for gender affirmation, i.e. puberty blockers, cross-sex hormones, and surgery for distressed minors. 1, there is no evidence of suicide risk. 2, puberty blockers are not safe or irreversible. They are not a pause. We're not tape recorders. We can't pause puberty and go on. 3, there is no robust evidence that gender-affirming treatments provide substantial benefits to children. And 4, their critique of the Australian Family Court's reliance on the Diagnostic and Statistical Manual of Mental Disorders, 5th edition, DSM-5, by American Psychiatry Association for diagnosing gender dysphoria was deemed inadequate. And lastly, the focus on Gillett competence, which assesses a child's ability to consent to medical treatment, has been too narrow. The Cass Review emphasises that informed consent must also consider the quality of information provided to patients, ensuring they are fully aware of the potential risks and outcomes of the treatment. I'll comment that the exposure of the WPAR files on March 5 showed that medical members of the association know all too well that minors are incapable of informed consent. Gender-affirming treatments for minors are seen now as the world's biggest medical scandal, with Section 3 and 2, the government, are actively participating in the scandal because you're removing roadblocks and pipelining minors to gender clinics. We urge you not to dismiss these concerns as mere moral panic or part of a cultural war. The stakes are too high. Every stakeholder's concerns must be considered in good faith. Trans rights, women's rights, children's rights, parents' rights, and LGBT rights are all human rights, and none should be compromised for or diminished by this bill. And I'll make note, our organisation have transsexuals, detransitioners, parents of trans children, psychologists, doctors, teachers galore. We're a mixed cohort, and we decided we'd be a mixed cohort so we could get a 360 on these issues. Thank you.
Thank you very much.